Thanks for fitting your schedules into mine. Fortunately, Clem doesn't blame you guys for the absurd judgment against Greensnake. He liked our motion J&OB papers. The whole case is absurd. I mean, plaintiffs run into each other and get hurt? Duh. So you're my appellate team. Josh, you have the laboring oar. Fred stays first chair. Scotia, you can read drafts and support Josh.
Epson and I agree on this. We got screwed at trial. Plaintiff's brain injury makes them pathetic, and the jury bought this idea that if they had known they could fall off and get hurt, they wouldn't have taken a scooter ride. Everything about causation in this case, from plaintiff's testimony through the experts trying to talk about the efficacy of warnings, is ridiculous.
I really appreciate you two calling me into this case, but I'm worried about what I can do for you. I saw the motion for new trial papers, and there's not much about objecting to this crazy testimony. He did not want me to spend time with the dailies before this meeting, so I really don't know what happened.
Plaintiff's papers are junk, and Judge Flink hallucinates.
Maybe we should look at the dailies for the causation witnesses before we invest in an appeal. I'm not as confident as Fred.
I'd like to give the trial briefs, dailies with causation testimony, and the motion for new trial papers to Grayson. I don't think it'll take her more than a day to determine if this bird will fly.
That'll blow the budget for sure. No way.
We all know Clem Head wants an appeal. Diving into details and dailies now will waste his money, our time, or both. You two get on it. I'm going to call Clem and tell him it's a tough case, but we can do it. Clem, it's always great to see your name on my phone screen.
Yeah, it's nice to talk with you too.
So how's your new Callaway Epic Flash playing off the tee?
Really great, but I don't have time to talk golf today. I have got to get down to business on this Greensnake appeal.
Of course, what's on your mind?
I have about 4 months of bills with your guy newbie charging a lot of time, and I haven't seen a draft brief. What's up?
Newbie is one of those cautious appellate lawyers. He's having a little trouble shaping the record to fit our good legal issues.
How hard can it be? The self-serving, I wouldn't have done it if I had known testimony really irritates me. And I'm sick of so-called experts who make excuses for people who do obviously stupid stuff. This is our third loss on product warning in the past 2 years. It's completely out of control. Pretty soon we'll need warning labels on stairs, coffee cups, cell phones, everything.
I get it. It's just that California law is pretty lenient on stupid consumers.
Fred, you are not panel attorneys. We pay you big bucks to find solutions to California problems. Be creative.
Clem, we appreciate
If you guys can't figure it out, I bet Horvitz and Levy can.
No, I'm sure we can.
Seriously, California is a legal hellhole. We need to send a message to the judiciary that we're mad as hell and we're not going to take it anymore.
Understood.
Just get your guy newbie to write the damn brief or write it yourself.
Of course. I'll get you a draft brief within 2 weeks.
Thank you so much for taking the time to get together, especially you, Epson.
Good timing. Clem expects our brief this week.
Well, I have a draft for you, but I'm not going to hand it out till the end. Scotia proofed and site checked it. You need to know about some problems that may not be obvious.
Appellate lawyers are supposed to bring solutions, not problems.
Please bear with me a moment. There's no California law for an argument that what I would have done is inherently speculative. That is why the citations are from other states, and they're much more fact-specific than I would like. Plaintiff's expert admitted that not everyone takes warning seriously. Duh. But it is out of context to say he even recognized the possibility that these plaintiffs wouldn't have taken the warning seriously. Also, we didn't object to plaintiff's testimony or anything that the expert said on causation. This appeal might be frivolous. We ought to at least consult with Grayson.
No Grayson consultations. I told you, it's too expensive.
Look, Joshua's brief would be great if the record supported it. Unfortunately, there's no issue in this case except causation. And our engineer's explanation for why Greensnake didn't put a warning label on the scooter is the stupidest testimony in the entire case.
Enough chit-chat. I'm going to read your brief, I'll make minor edits, and then it goes to Clem.
Plaintiffs and Greensnake served their brief last night. I saved it to the case management folder and printed a copy. They've associated Barton McKinnon, who is a great rep and does a lot of plaintiffs' appellate work here and in Los Angeles. He nailed us repeatedly. He nailed us on the standard of review and the failure to preserve arguments by objecting at trial. And somehow, a statement about inadmissible and highly prejudicial expert testimony got into the AOB. Bart says not only was there no objection and no record reference, there was no such testimony. We've got trouble.
I put that in. I distinctly remember the testimony.
Yeah, that wasn't a depo. Judge Flink denied our motion in limine, said it was a close call. But ultimately, plaintiffs never asked our expert for that testimony at trial.
My bad. But like I said, appellate lawyers are supposed to bring solutions, not problems.
I have two solutions: apologize and retract, or ignore it.
Ignore.
I bet Grayson wouldn't say that.
That's another reason for no Grayson consultations. Clem would kill us if we retracted anything.
What about the failure to object to that "I wouldn't have done it" testimony?
That wasn't categorically inadmissible. That's what we're trying to do here. It's something I wasn't thinking about in the heat of trial. Can't you call it inherently incredible?
A branch of substantial evidence runs that way, but that's not really what we argued in our brief. I suppose I can cite some of our jury argument and motion for new trial papers.
Just do your best with what we have. That's all Clem can ask of us. I'll send in the plaintiff's brief, no comments.
Here's plaintiff's motion for sanctions against us and Greensnake. There are three things you should know. First, substantively, it relies mostly on their brief. It gets a little personal about us being a big firm and we ought to know better. It suggests that we need reminding that we shouldn't be filing frivolous appeals and making frivolous arguments. It then emphasizes that we didn't even reply to the worst defects like the expert testimony that didn't happen. It asks for $115,000 in appellate fees and $15,000 for burden on the court.
I didn't know any of this was going on. What does Clem know?
Nothing. We just got the motion.
I've gone to a couple of programs where the judges of this court have said that they're not a sanctions court. They believe that sanctions bring more heat than enlightenment.
Good. I'm going to call Clem and send it to her at the same time. This motion is a personal attack. We have colorable arguments. And like you said, it's not a sanctions court.
You should also tell her that this is a tough appeal and we can't guarantee a win. You should let her down slowly.
I am going to call the case of Noah and Emma versus Greensnake. Counsel for the appellant, would you like to?
Good morning, Your Honor. Joshua Newby on behalf of Greensnake.
Counsel, I'm sure you would like to talk about the substantive portions of your appeal, but because of the sanctions motion, the panel would like you to first discuss why this appeal meets the Flaherty test for not being objectively frivolous.
The issue in this case is whether substantial evidence supports the jury's verdict that my client is liable for failing to provide adequate warnings. We have established there is no substantial evidence supporting the jury's verdict. The problem in this case is the jury was emotional and sympathetic, and they were concerned because the plaintiff suffered brain damage, but that's not causation. Of course, every plaintiff who's been injured is going to claim that if they had been warned about the activity that injured them, they wouldn't have engaged in that activity.
Mr. Newby, what authority have you cited in your brief to support the notion that plaintiff's testimony that they wouldn't have ridden the scooters if they'd been warned about the need to wear helmets is inherently speculative? I don't recall any.
I'm not specifically recalling any, but I'm sure there's some here in our brief. Another problem in this case is that plaintiff's expert testimony lacked foundation and was speculative. We brought a motion for a new trial that was erroneously denied.
Mr. Newby, isn't it true there was no objection to the evidence, and in fact the issue has been waived?
Well, I'm not sure of that, Your Honor. There must have been an objection because the argument's in the brief.
Mr. Newby, what's the record site for that objection?
Well, Mr. Newby, while you're looking for that record site, perhaps we should hear from respondents.
Thank you. And may it please the court, Barton McKinnon, on behalf of respondents Noah and Emma. California courts have the inherent power to dismiss frivolous appeals.
Counsel, are sanctions in this case appropriate under Flaherty?
Yes, Your Honor. The Flaherty factors absolutely have been satisfied in this case.
Is that an objective or a subjective standard?
Both. The improper motive standard is tested subjectively. The focus is on the good faith of appellant and counsel. Now here, while the appeal is bonded, the purpose of this appeal is to harass my client because Green Snake simply does not like the result of the jury's verdict. The second standard is tested objectively. That is, whether the case lacks any merit from a reasonable person's perspective. Now here, appellant omitted facts from the record, made affirmative misstatements regarding the record, including specifically misstating that an objection was made to expert testimony in order to manufacture a basis for appeal. They also have made legal arguments that lack any citation to authority whatsoever. It is important to note that the two standards are in the alternative, each providing an independent basis for sanctions. We believe that the sanctions are warranted under either standard based on their conduct in this case.
Mr. Newby, have you found that record site the court's asked for?
Not yet.
Mr. Newby, please explain why your appeal should not be found to be frivolous and why you haven't violated the professional rule 3.1 and 3.3.
Well, Your Honor, professional rule 3.1 says that a lawyer shall not bring or continue an action, conduct a defense, assert a position in litigation, or take an appeal without probable cause, and for the purpose of harassing or maliciously injuring any person. It's a two-part standard. We need both prongs. We bonded this appeal. The interest accruing on the judgment means that the plaintiffs cannot establish that there's any harm that they suffer due to the lack of finality caused by this appeal. Even if the court believes that the appeal lacks merit, Green Snake had a legitimate interest in trying to establish that this kind of self-serving, after-the-fact conclusion does not establish substantial evidence. It does not arise to substantial evidence. Green Snake did not appeal to harass or injure the plaintiff. Green Snake appealed to establish that such self-serving conclusions do not establish causation. Our arguments have been brought in good faith. They are supported by existing law. The problem is that there's no controlling authority in California.
Mr. Newby, speaking only for myself, I have to say that your appeal does not appear to be based on any existing authority or any good faith argument for extension of the law. You falsely represented to this court that in the appeal that there was an objection, and you repeated that representation to the court. And our review of the records, my review of the record, says that no such objection was made. Your apparent lack of candor to this court is very concerning. Let's hear from the respondent regarding the appropriate amount of sanctions that should be awarded in this matter.
The sanctions payable to my client should reflect what is necessary to redress the undue burden that they have suffered, and also to deter the same type of conduct in the future. Now, the factors relevant in this court's determination of the amount of sanctions to be awarded include: 1, the amount of respondent's attorney's fees on appeal; 2, the amount of the judgment against the appellant; 3, the degree of objective frivolousness and delay; and 4, the need for discouragement of like conduct in the future. Appellant's conduct caused my seriously injured clients to expend what funds they had on hand in an obviously frivolous appeal. But appellant and his counsel didn't just harm my clients. This appeal caused this court to expend many hours to assess false claims of error. It also delays justice for the many deserving parties who really have genuine issues. Consequently, as stated in our brief, we believe $115,000 jointly and severally payable to the plaintiff and $15,000 payable to the clerk of court are appropriate.
Thank you, counsel. We appreciate your argument here today. Again, speaking only for myself, this appeal is very, very concerning. Mr. Newby, you should be aware that in the event this court awards sanctions, which appears likely at this point, we must report them to the State Bar pursuant to the Business and Profession Code, Section 6086.7. And you should familiarize yourself with your own duties to report under that code. Thank you, counsel.
You're telling me that not only have we lost our appeal, but your firm and our insured are being sanctioned for making stupid arguments? What an embarrassment to your firm and to us. How did you get us into this mess? I thought you guys were professionals. Needless to say, we'll bring in another firm to review this appeal and see what can be done. We'll probably expect you to pay those fees. And we can't have our insured pay sanctions because of the conduct of our assigned defense firm. So if the sanctions stick, be prepared to pay them. Of course, this means there'll be an audit of all your fees on this file, and we'll need to think about who is going to handle our complex California cases from now on.
You've just seen me play a full-rig, two-gun deck, ocean-going jerk. I hope you will remember me for something else. Now I'm just me. Sad as it is to focus on Newby, he had many chances to stop this train before the wreck. Yes, it is the job of an appellate lawyer to find solutions, but right solutions sometimes don't fulfill everybody's original goals. If Newby had followed the true moral compass course, he would have saved his own career, several other careers, and a whole law firm. Perhaps he would have put his newly minted partnership at risk. But defeating risk and taking risk both require courage. What distinguishes a great appellate lawyer is not some particular skill of advocacy, but the courage to proceed always on the true moral compass course.